And we're live. Hello, this is Tom for Tabletop Tap Room. Well, I guess this is officially a court reporting video. We have with us Kim Wincen of Wincen Works from New Zealand. And hello, Kim. It's nice to finally meet you face to face.
Hi, Tom. Nice to chat with you. Yeah, we're all getting faces lately. First David, now me.
Yeah, well, no, it's good to get to know each other. And I gotta say, I don't know why you don't have a YouTube channel, because you got a great voice for this.
Thank you.
I think you could be like on radio and you would get highly paid. You could do a YouTube channel and it would probably be a hit. But that's not what we're here to talk about. We're here to talk about you getting. You're going to have to help me out with this. You were served in New Zealand with a complaint from Justin Lanassa of TSR fame.
Yes.
What is this? How is it that you got served? I don't. Maybe you could explain this. What happened?
Okay, so as you know, I have been a big fan of what has been going on in the new TSR fiasco, and I've been documenting it and sharing my opinions and commenting. Now, it seems Mr. Lanassa has a grievance with this, and he's employed what we have in New Zealand, which is called the Harmful Digital Communications Act, which is, it's a bit of law that, as far as I'm aware, is unique to New Zealand. But basically what it allows you to do is to essentially request an injunction for people to stop posting online if it's harmful to you or if it's defamatory or anything like that. So you can essentially just tell the court, hey, this person should stop, and the court will issue an order if they agree with that, saying like, look, you have to stop, or you have to take it down, or you have to apologize. It is also does have some provisions for some very extreme things, like if you harass someone to the point of causing harm to them, as in making them self-harm, or you post, we won't use the standard term on because of YouTube, but let's say unconsensual intimate imagery of individuals. Is a thing that it very specifically covers too. So it has varying degrees, but the general idea is that if someone is doing this, you're getting harassed on Kiwi farms or over Facebook or Twitter or things like that, or in your comments on your YouTube, and the person is in New Zealand, you should be able to get them to stop that without having to go the full hog and going for a defamation suit or an intentional infliction of emotional distress or something like that. When really all you want is for just them to stop. They need to stop.
So, well, this seems like a good law then. Is so this suit that has been leveled against you, are you able to talk about it at all? Are you able to? Yeah, go ahead.
I'm not going to go into any of the specifics or the details there, because I have to be very careful about what I say about it, because it is obviously an issue of authenticity. I'm happy to talk about the general structure of it, what it means, what the steps are going forward from here, and what the possible consequences are, and things like that. So,
let's do that. What is the structure? What's going to happen now that this suit has been brought against you?
All right. It's not really a suit, is one thing I want to clarify, because this can't result in the wide variety of rulings you can get from a suit. For example, there is no opportunity for Justin to ask for damages in this case. To him, if he wants to do that, he has to actually sue me under defamation or something like that and go through the whole 9 yards. However, it does work quite the same in that I have been served with the complaint, which, in order to make this more accessible, it's not a formal complaint written by a lawyer. It's an online form that anyone can fill out, and they submit to the district court. The district court then does a little bit of back and forth, and they provide me handily with a form I can fill out to respond to this and submit it. And I've got 10 working days to do that from the day that I was served, which was Friday.
Okay. So
after that, Justin gets one more reply, and then we see what happens.
We'll see what the judge says. So
Yeah.
what is the worst that could happen to you? Let's say that the judge is just a Kool-Aid drinker for TSR, and he's like, "Yeah, Kim, you're a bad boy." I mean, what's the worst
What
that
can happen is he can specify that I need to take down various Facebook, Twitter, and blog posts, that I need to post a correction to them. Or post a correction to them, or post a public apology, and stop tweeting, basically. So there's no potential for me to get fined or have any sort of criminal penalty unless I disobey the judge's orders after he does that. And even if he does that, I have the opportunity to then request a removal of that order.
So basically, the worst that would happen to you is you'd be told to stop being mean to Justin.
Yeah, please stop being mean online. So
Okay. I mean, I gotta laugh. I gotta laugh at that. So, what would a correction or an apology look like for in this case?
really, all I would expect is you've probably seen them all. There's a couple of litigious people in tabletop role-playing game circles who I'm not going to name because I don't want them to join in on this. But you will have seen people, they have crossed posting apologies that say, like, on this Tate, I said so-and-so did this. I did not witness this personally. I have no evidence that that this occurred. It was wrong of me to state this. I apologize. And that's it. That's basically what they mean by an apology. So you've got it on record that you were wrong and you shouldn't have said that.
Oh, well, we have a YouTuber who apparently knows more about the law in New Zealand than you, and they're saying, talk about the jail time, Kim. Apparently somebody thinks you could go to jail for this.
Okay. Now, there is technically some offenses which can include jail time in this. It's under section 21, but it's only if I fail to comply with the order.
Oh,
so
this person's out their rear end. They don't know what they're talking about.
Well, like there are 3 criteria under which you can get jail time under this here. So the first one is if the judge gives me an order and says, like, take down your stuff, and I just refuse to, then I can get a imprisonment term not exceeding 6 months or a fine not exceeding $5,000. As you can guess, you have to be pretty extreme in your non-compliance to get the whole 6 months.
Okay.
Now, there is causing harm by posting digital communication. This isn't one that I've been notified that I am actually on the hook for in the complaint. So I'm not actually worried about this one. It's not liable, but it again can be up to 2 years. And that is for the scenario where this harassment has caused someone to, say, self-harm, or they have started developing like a neuroses, being agoraphobia or something like that, or they're now requiring counseling because they've got extreme anxiety and depression, things like that.
Okay.
There's quite a complex analysis done in determining like the harm of it, which includes things like the age and the characteristics of the victim. So if you're harassing a teenager, that's worse than if you're harassing, 40-year-old man. And obviously, if you're attacking someone who is incapable, like they're in a granny home or whatever, the judge is probably also going to frown on that.
Okay, so let me. No, go ahead.
Yeah, and the last one is the intimate visual recording without consent, which I definitely have not done.
Okay, so let me just springboard off of that. So, like attacking someone who's a minor or somebody who has intellectual disabilities, or something like that. So somebody who has done that sort of thing could actually get jail time.
Yeah, it is possible, if it is found to be harmful to that person, that the court has the authority to issue that potential jail time in there, or a fine.
So, referring to somebody's daughter as, like, say, I'm going to use a distasteful word here, like a retard, or calling somebody's son a, trainee, something like that. That would qualify for that jail time.
Yeah, if it resulted in the direct harm. So if there was specifically, they could point to harm, because harm in this case refers to, it's clarified in the act, serious psychological harm. So if it slides off them like water off a duck's back, no. But obviously the risk for the person going is in, they don't know if it's going to cause harm or not. So it's extremely ill-advised to do that if you're in New Zealand, because if it does do some serious harm to the person, they can lodge a complaint under this, and the judge can issue you an actual hefty penalty for that.
All right. Well, there's a question on screen here. I just wanted to get in because you had mentioned that, and I just wanted to get in those follow-up questions. But there is a question here from Wizard Tower Games. He says, Kim, question for you. There will no doubt be a hearing. Does Justin have to appear in person or on video, etc.?
Most stuff in New Zealand court now allows you to appear in video, particularly thanks COVID-19. That promoted that as a big issue. But particularly since there is the circumstances here where Justin is not in New Zealand, they will almost certainly allow him to come in by video. I myself actually have to do a bit of back and forth with this, because this has been set up in the Auckland District Court, which is in the other side of the island from me. So I either need to get them to agree that I can go in only by video, or to ask them to transfer the proceedings to the local district court so I can show up in person, depending on what they prefer.
Oh, interesting. All right. Well, we have another VG APMI. I heard that Mr. Lanassa is suffering extreme anxiety over this and has sought help. So your actions, along with Tommy, Don the Con, and the attacks by your clown in here. I don't even understand that. Do you wish to respond to that? I don't know. It's coherent.
Yeah, it's difficult to pause that there. If Mr. Lanassa is suffering from extreme anxiety, I hope he gets some help, and I wish him well with recovering from that, because it's not something I would really wish on anyone in there. But as I said, that is a very specific case of the act, and I have read the complaint front to back. It isn't an issue that's been mentioned in there, so it's not an issue being discussed at this time in the act. This motion is purely about basically get him to stop posting these things, get him to take down what he's said, and please make him apologize. And the judge will be able to decide whether I need to do any or none of those things.
Oh, okay. All right, let me get a few more comments in here. Well, the New Zealand law makes sense so far. That's good, because I've read some laws here in America that make no sense to me.
We have our own in New Zealand that are. Let's just say it's a good sign when your law lecturer says, "Have a try deciphering this."
Really? That is a guy I am like lining up to not vote for.
Yeah. We have some in there where there is one where they actually, like the law says, for the purposes of clarity, and it shows up in your statute interpretation classes, because they so as you can see, this is objectively more confusing after you read the bit following the for the purposes of clarity than it is beforehand, because somehow when they pass the bill, they put in like word salad where you're just like, I don't know who's culpable or what the circumstances are anymore. I thought I understood going in, and now I'm like, So yeah, I agree. I support this law, even though I am like, in the barrel for an order under it. I support the law because we do live in an era where there is like online harassment is a thing.
Yeah. So
it is
good law for us to adopt here in America.
Yeah, I think it would be a good one in there, because and one of the points in there is it does very specifically say that the Human Rights Act in New Zealand needs to be considered, which is the one that gives you freedom of expression and freedom from bigotry and things like that. So it's not like an absolute you can't be mean to people. It is if you're mean, it needs to fall within this protected category. And I should clarify, freedom of speech is a bit different in New Zealand. We don't have an absolute rule of freedom of speech like you do in the US, where its First Amendment says the government shall not interfere. We have freedom of expression, which is broader, and also says that the government needs to weigh up any decisions that it makes against this right.
Okay.
So they can't just, if they want to pass a law, say banning you from talking about Dungeons and Dragons because it's satanic, they actually need to address and consult with the Attorney General of would this be a violation of people's freedom of speech, freedom of expression rather. And the Attorney General is obligated to give a frank response there. So, no one wants to be elected for passing the law where the Attorney General went, this is complete nonsense and would be an utter violation.
Well, I would love to actually dig into the difference between freedom of speech and freedom of expression, but maybe we'll table that for another day. And because you just opened up a whole rabbit trail that I think would be fascinating. But let's stick to the purpose at hand. Well, VG, you would know considering your alter ego. And then we've got Don, go away. No one wants you in here. No one likes you. Well, actually, that's not true, VG. I like Don. So one person does. And then you might want to get the whole multiple personality thing checked. So there's a lot of back and forth in here. And RPG Grandma says the video is convenient, so that is reasonable. And all right. It looks like, no, geez, you guys are tearing it up in the chat. Lies, you want to ruin TS. Well, actually, TSR is bankrupt, and the CEO filed for bankruptcy, and it's about to go away and no longer exist. So I don't know how we can ruin something that's bankrupt.
Isn't it Adamantite Games or something now is the successor to it?
Well, yes, I suppose if that would be true, if all the assets that should have been disposed of under TSR so that the creditors could get some money were transferred to it, right? That would be my interpretation. But we don't know if the assets that should have been disposed of under TSR in the bankruptcy were actually transferred to Adamantite Games. So if Adamantite Games is the successor, then it must have the assets from TSR. Would be my interpretation of that.
Yeah.
Would I be wrong?
I don't know if it's the formal successor owning the assets or anything like that, but it seems to be the one that released those pesky orcs, which seems to be strongly connected to those pesky goblins.
Well, that's true. So more of a spiritual successor. All right, I could go with that.
Yeah. I don't know the specifics. Same author though.
So Thyanis says that Kim, you are a nicer man than I. God bless you.
Please tell that to the judge.
He's certainly a better dresser than me. That's a nice looking full Windsor there that you've got tied.
Oh, thank you. Yeah, I was in Air Cadets, and it was the only acceptable knot there. So Elf8 says hello from St. Louis. RPG Karen was replying, and then some more from VGA. The day is coming when gamers will line up to say sorry to Justin. They will beg him as he is the truth. They will beg him as the truth is coming. Okay. Okay.
All right.
Well, that will certainly be nice for him when that happens.
I agree.
I don't know how or why, but I guess that you should probably tell him that that might help with his anxiety.
Yeah, good point. Dawn will be exposed. Wizards and their backing, the destruction of TSR will be exposed. Kim, did you not read the bankruptcy? If I can rabbit trail here a little bit, you read the documents involved in the bankruptcy. What would be your evaluation of why TSR fell apart?
Well, I think the fact that they're like, they had pretty much no revenue stream. Like, I think it was what, $30,000 or something over 3 years, which is just not sustainable for a business. And they didn't really establish any goodwill. Like, I don't know what the rates and things like that in Lake Geneva are, but I'm led to believe it's actually quite an expensive town to live in because it's the playground for the rich from Chicago. So that tends to make everything expensive. And yeah, that would be my assessment. Is it wasn't making money. So, and I have no idea why it would spend, if it's only earning $30,000 over multiple years, why it would attempt to spend hundreds of thousands of dollars on a court case with a behemoth like Wizards of the Coast / Hasbro, which has bottomless pockets. Like,
well, and not just that. I mean, just on rent and on so much stuff.
Yeah.
It just seemed like I had a friend who attempt to subsidize their lifestyle with credit cards, and then one day,
oh no,
and one day that all came. The crows came home to roost, or the chickens came home to roost. This seems like some of that.
And I mean, like, we're both in the hobby. We know this is not a hobby where people make extravagant amounts of money. Like, a lot of this has expanded recently because there are cheaper options for distributing your material, like electronic publishing and things like that. So you no longer have to get the upfront money to put together a paper product or have the book published in bulk or anything like that. So, like, it's a strange hobby to like go all in on and go, I'm just going to invest so much money at the start and assume it'll make a lot of money.
Yeah. So let's get back to your case. We've rabbit trailed here a little bit. It's what do you anticipate? The final result of this, or is that something you can't speak to?
I mean, I'm defending myself, so obviously I am heavily biased in this. I also just want to clarify here before I go into any more about this. I'm not a lawyer. Most importantly, I'm not the lawyer for anybody here in the chat or whatever. This is not privatized legal advice. And for the love of God, please do not assume we have a lawyer-client confidentiality agreement. Don't tell me about anything you've done illegal. That's illegal, please. Don't tell anyone on the internet about that. But yeah, how I'm anticipating is I've got to file my response, which will, as I said, I've got 10 working days to do that. That's basically my opportunity to tell my side of the story and submit my thinking there. After that, Justin does get a chance to just reply to only what I've addressed. So you're not allowed to raise new things or to try to pivot into a new angle or anything like that. After that, I expect we will probably have a couple of mandated court meetings, because that's the thing they are doing in New Zealand now, is in order to try to streamline the trial and to minimize the need for a trial in the first place, they're trying to have more court-mediated meetings where they actually discuss what is the structure, what is actually going on here, what do both of you want, what do both of you think is happening, and sort that out. In the event that we cannot come to a conclusion where one of us like settles or discontinues or anything like that, I believe the document says I should expect a half-day trial where I will get to speak on my behalf. Justin will presumably speak on his behalf. Neither of us is employing a lawyer at this stage. And then the judge will probably the same day make a decision whether or not an order is required. And if so, they will specify what order needs to be, provided as such. It could be anything from, he says, please correct this one blog post, to please stop doing all of this and post an apology and some corrections. And if the judge says do that, I'm fine to do that. As I said, if I really think it's unjust, there is a option of recourse I have where I can file for a removal of that order. But I just at this stage don't see that it has the muster to be anything that extreme.
Okay, well, there's some interesting developments here in the chat. I'm falling way behind. The chat is going fast and furious, but VG APMI has announced that TSR is not bankrupt in Wisconsin. And I find that rather fascinating. I don't know if we want to comment on that. What do you think?
I do. I am admittedly not a scholar of U.S. company law or that, but it is my understanding that there is actually only one TSR LLC, and that what happened is it's registered in Wisconsin, and he's registered what's called an alien corporation in North Carolina, which essentially allows him to operate it as though it were registered in North Carolina. But if one of them goes bankrupt, they're both bankrupt. It's not, it's not a photocopy type scenario.
Right.
Because otherwise it would be very confusing why that bankruptcy had, for example, that TSR claiming rent in both North Carolina and Wisconsin. Again, not a legal expert, but it is a bit weird.
Sure. All right. I just find this funny. VG probably should consult with Justin, I'm sure. Thank you for asking. Yeah. And and now that's an interesting comment. Are you planning to fire up TSR in Wisconsin? You are jealous. Let me just catch up on some of these comments and see if there's a good question in here, because if one of the audience has a good question, I definitely would like to have you field it. TSR was never going to save gaming, which didn't need saving. Gaming is a broad spectrum of people who play games of all sorts of ways. Yep. Oh, Jason Elliott, welcome to the show. Hey, Kim.
Hey.
Sorry I'm late. Good to see you. We like Jason. One of our people. We love seeing him at conventions. Wave there. Would love to have VGMI on my Tuesday night show. You can come in. I will let you talk first. Yes, that would be great. Somebody new to the show, Torque 2100, at Tammy, Veralt, Nailhead, etc. I don't understand that.
It's for my comment earlier.
Oh, okay. No, nail on the head.
Yes.
Nail on the head. I'm not keeping up. I'm falling way behind. Apologize. This one time at bank. Shut up, Jason. And DM Kurt, is Justin claiming damage to his mental health because people hurt his feelings? Is there a not guilty by reason of insanity defense in bankruptcy court?
Oh, that's an interesting combination of questions. I'll be honest. I don't feel confident, having read the complaint, saying exactly what Justin is claiming in terms of that there. Some things like counseling that have been mentioned. Now, it is a legitimate claim in New Zealand that if you are traumatized by the behavior and the communications of others, you can claim that as harm. But that is generally, at least to date, to my understanding, has always been very, very extreme things, like people emailing your employer with claims that you perpetuated a crime of a vile nature upon them. Sending threatening pictures with threatening pics of you with threats written over them, stuff like that. Real, clear-cut harassment.
What if like, say, hypothetical here, let's say your son had died, and then they were like trying to send autopsy photos of your dead kid, even though there was no autopsy done because they had died in the hospital. Would that constitute, under New Zealand law, doing harm to somebody?
It could, if it did the harm, because the specific part about this section of the harm is you have to show that there was harm done. So you would actually need a report from a licensed psychologist saying this person is experiencing PTSD as a result of being sent this there. But yeah, and I think you would be pretty safe to say that you wouldn't be able to say reasonably argue that, oh, yeah, no, that's normal. That's just regular correspondence you should expect. Is like, everybody sends autopsy photos to people along with like, discussions about like their deceased child. That would probably fall into the category of grossly offensive, and I can't imagine any judge in New Zealand saying that that is a reasonable thing to send to someone. So,
Yeah.
or that is something that needs to be protected under freedom of expression.
I love that quote, grossly offensive.
Yeah, it is the terminology that is actually used in the act for one of the criteria, because how the act defines the potential let's say offenses for the categories that can get you to have to like take things down, apologize, things like that, is they're called communication principles. And principle 3 is that you will not send people material that is grossly offensive to a regular, reasonable person in the shoes of the defendant, so of the applicant rather. So it allows for a certain amount of circumstance and things like that, but it all has to be, you can't send people stuff that nobody reasonably expects to receive that. So, for example, if there was someone from New Zealand sending you taunting emails and random autopsy photos and saying, this is your child who died, I would think it would probably be a slam dunk to get the court to pretty quickly issue an order saying, stop doing that.
That would be nice. So for Justin to prove that, the mental harm, he probably would need to see like a counselor or a psychologist, or check himself into an institution of some sort.
Yeah, he would need to provide some sort of expert evidence, basically, like that. So that would be like a report from a psychologist or a report from an ER doctor if there had been a self-harm incident or something like that. As you can imagine, whenever jail time comes up as a potential offense, courts are very, very generally very careful about that, because it is such an extreme consequence. So they do want to make sure that everything is correct, and that they are not like, going to have to apologize for this in 6 weeks when it turns out, oopsies, we jumped the gun there. So
this is not like Alice in Wonderland where the queen is going off with his head.
No. It's part of the reason why this act exists, really, is in part because dealing with those things otherwise was quite an extreme process. Like, without this act, for example, if someone was posting your intimate photos on Twitter with like, death threats written across them there, you would first have to prepare for example, a case on the basis of intentional infliction of emotional distress. Then you would have to apply for an injunction as part of that case to please prohibit them from posting any more of this. Then they get to argue that I think that's, that's unfair, and I think they need to show why my free speech needs to be like mitigated.
Oh my God.
To this extent. So, you could end up with, basically, it could very easily be like 6 months of back and forth before you actually get an outcome. And then in order to keep that outcome, you have to go all the way through with that and potentially spend tens or thousands or hundreds of thousands of dollars to get this outcome where all you really wanted was just, could they stop?
Yeah, stop doing this. Stop doing this horrible thing. Okay, yeah, go ahead.
Yes. Yeah, and particularly if the person is what's known as judgment proof, so they don't have any money. So even if you get all the way through to the end of the tort and you get like, yeah, I've got a ruling of $1 million of damages, and the person like owns one secondhand car and has $50 in their bank account, you've spent $100,000 to essentially just get them to stop doing something which is pretty, in the minds of most people, pretty clear cut. You shouldn't do that. Just stop.
Yeah. So this is a very enlightened law that New Zealand has. I'm really impressed with this. I think we should adopt it here in the States. But Don says something here. Wizard Tower Games says, faith in the law is what I have. Manipulating the law is something I will leave to others. Is there a possibility here that this law is being manipulated by the individual in question to just, harass you, cause trouble for you?
Yeah, that there are probably people who have that opinion. I'm not going to say my opinion on that here because I don't want it to show up in my filings or anything there. But I will say this law has been somewhat controversial in New Zealand because there has been concerns over things like who gets to decide what is hate speech, who gets to decide what is grossly offensive to the regular individual. What do we do if people do try to weaponize this law or do try to use it to silence and things like that? It's a relatively new law. It was only passed in 2015, and one of the other things is it's only a law that applies in the district court, which is basically the lowest tier of actual court in New Zealand. The only thing lower than that is the small claims court, essentially, magistrates court, where you can go over real petty things like, this person owes me $200 and they won't pay me. District court is the lowest one that can handle actual damages and things like that. So far, to the best of my knowledge, there haven't really been, I did a quick research, there haven't really been many escalations of it to higher courts or any real iconic cases which have challenged, is this a valid law or not? I think there was one where it's in there because it's an important ruling, but it was a pretty clear-cut ruling in that, you can't use this law to stop the news from reporting that you were convicted of a crime.
So if what you report is true, if what you've put in your blog post is true, what you have reported in your tweets or on Facebook is true, then this law doesn't apply.
Yeah. Basically, this one in there, I will just go over the basics because it's part of the structure. I am on the hook there are 3 issues which I am challenged on. Are my posts grossly offensive to a regular person in the shoes of Mr. Lanassa? Are my posts harassing? And do my posts contain false or misleading information? So those are the 3 things I have to speak to in my response. And if the judge looks at it and concludes that I am innocent on all 3 criteria there, that's it. I'm not on the hook for anything.
Okay, well, yeah, I've seen a lot. I have not seen everything you've posted. I've seen a lot of what you've posted because I think I follow you on Twitter and on Facebook. So, yep. I've not seen it, but again, I'm not a judge in New Zealand. I've only played a lawyer in an RPG once, so I don't know. But I think you're probably in the clear.
I'm not expecting anything dramatic from this. Like I said, the absolute worst case scenario I would expect from this is the judge does tell me, please take down this nonsense. And if you want to go into it again, please file a request to remove the order, basically. And that could legitimately happen because this is also, I feel, quite a niche topic. And I'm not confident that the judge knows or cares about 90% of this, and that's reasonable. I don't expect the judge to want to spend 100 hours researching the history of what went on here and read thousands of pages of exhibits over what is essentially a stop or don't stop there. Right. Most of the reports I've found, the reported cases, have been quite extreme things where it was very clear cut. As I said, someone emailing employers with, did you know this person perpetuated this crime of a vile nature on me? And one of the points of that was the court's opinion was, if that is true, go to the cops. Don't, email people about it. Go to the cops and get a proper criminal investigation. And another one was basically some neighbor drama where the person was posting non-stop on Facebook, this person is terrible, this person is evil, I hate them, da 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 da. And I didn't read it too closely, but I believe that were some allegations of that person abusing their child and stuff like that. So it's not a petty stop arguing on Twitter law. It's a don't use social media and the internet to harass people or it seems like a stronger version of anti-defamation laws in the US. There's a lot of overlap with harassment and defamation in there because like the falsehood and the that obviously would fall under sort of a light version of defamation, but easier to action and more accessible to the public. Similarly, there's like the things in there which is a much more accessible way to guard against harassment, things like that. So
yeah. Okay, that was great. I'm glad you read that. This is interesting because we get to learn about New Zealand legal system. Yeah, you have been such a wealth of information when we've talked, because you seem to have a grasp of the American legal system as a common law system. And I've always appreciated that. And it's kind of cool to learn a little something about New Zealand and not be such a parochial American mired. And the reason why I value that is because my senior year of high school was in England, and the government teacher who did the half year class on American government was the student advisor for the senior class. And that meant that he accompanied us on our senior trip, which was actually to go see a Shakespearean play at Stratford-upon-Avon, which was Shakespeare's birthplace. And he warned us, if you embarrass me as a Bubus Americanus, you will fail my class.
Yeah.
And so his doing that really put me on notice. Like, don't be a dumb American in a foreign country. Pay attention to what's going on and don't be an idiot. And so I've always appreciated learning about other cultures, and I really appreciate you coming on the show to do this. So Jason Elliott says anti-slap laws exist to prevent people from using the courts. Yes, but you know what? What's nice about this New Zealand law is it seems like it puts, if you were poor and you couldn't afford a lawyer, it lets you have an avenue to get this kind of harassment stopped. Am I correct in that, Kim?
Yeah, this is one that is specifically intended for an individual to be able to respond to on their own. Like I said, they've created some very accessible forms in there where you can any individual can go in and can just type up there. Justin hasn't needed to hire a New Zealand lawyer for this, which obviously I have personal opinions about this one, but I think that is good, because I think the worst thing you would want is like some New Zealand kid going on to Kiwi farms to harass someone who beats them at video games or something like that. And that poor person then being told like, oh, well, sorry, you're going to need to find a lawyer in New Zealand who's qualified to file this, to stop this kid posting, threats to you and things like that. So it is intended to be very accessible. Like I said, it is, in terms of laws, it is very low stakes in terms of what the possible consequences are. It is sort of intended as that stopgap where you don't really want to go the full hog and go in for like a tort or seek damages or try to criminally prosecute someone and prove beyond a reasonable doubt that they did this and they had the requisite intention and things like that. You just want them to stop. So
yeah, it's, especially if you don't have the money to shell out $5,000 to retain a lawyer. I mean,
imagine the accessibility to justice issues that would create, and the way harassment mobs would adjust if that was the case. Like, right, okay, we won't harass rich people, but we will harass these poorer people from who are protesting and things like that. So yeah.
Well, there is quite a bit of cyberbullying that goes on in America, and wow, I'm really impressed. I think I might actually send an email to my representative in Washington over this. So I'm going to say thank you, Justin, for doing this, because now it's brought this whole issue to light.
I saw Jason had a comment there that I can address. Do we have equivalent of anti-slap law? We do not specifically have an anti-slap law anywhere in New Zealand, but what we do have is the client conduct ethics for lawyers there says that it's a breach of conduct for the lawyer to bring a spurious or unsubstantiated lawsuit. There's particularly things in there like you cannot allege fraud in New Zealand as a lawyer unless you have specific evidence of that fraud.
Wow.
Like that is particularly a called out no. So you can't do a like, yeah, we're just going to accuse them of fraud, yeah, and we'll hope we'll find it in discovery or whatever.
So, like, just say, yeah, they did fraud. It's $1 million worth of fraud. That doesn't fly.
Yeah, no, you can't just like go like, yeah, I got defrauded. Why? Well, just vibes, man. Like, I feel I should have gotten $1 million more out of this deal, or that, like, you know, they defrauded me. You actually have to, before your lawyer can bring that before the court, get some actual evidence that you can put to the judge and go, this is why I'm pretty sure I was defrauded.
Oh, okay. So let me throw another hypothetical at you. So let's say I want to go after somebody who said some mean things about me on YouTube, and so I'm gonna sue them for defamation of character, and because I don't want it to be done in a state court where they got a brand new slap law in place, I'm going to elevate it to, say, a federal lawsuit by claiming $1 million in damages. As a lawyer doing that lawyer would get in trouble if it was just totally spurious, wouldn't he?
Yeah, the lawyer would be on the hook for a breach of ethics. Also, that doesn't really happen in New Zealand because we are too small to warrant the multi-tier system that the US does. So we don't have county laws, state laws, and federal laws. We just have the New Zealand legal code, and the seriousness of the issue decides which court you go to. But it will not go well for you if you decide that, like, look, I don't trust the district court to handle this. I'm going to like add a couple of zeros to this so that it has to become a high court issue. Because at that point, the high court judge will be within their rights to just go, no. And in fact, I'm just going to use my authority to kick this back down to the district court and say this should never have been in my court in the first place.
Yeah, I've been in a courtroom once in my life where I got to witness the judge being irritated with somebody, and it did not go well for them that the judge was irritated with their shenanigans. And so I kind of like wrote it on my hand, never piss off a judge.
Yeah, it's one of those things where, like, I'm obviously on social media following and interacting with a lot of lawyers, and yeah, every time a lawyer is doing that, everyone is like, what is he doing? This is... Yeah. Occasionally, like, there is the theory that, say, Trump's lawyers do it purely because they want the judge to throw a tantrum at him so he can then request a new judge and hope that he gets one that he appointed or something like that. But generally speaking, you don't want the guy who gets to decide, you know, what is and isn't allowed to go to be angry at you.
Yeah. I would wholeheartedly agree with that. So RPG Grandma says, internet stalkers do suck rocks. That is an interesting expression. Yeah. So it's nice to see this approach. I agree. Yeah. No frivolous lawsuits than to harass others. Yeah, because, when somebody's using a frivolous lawsuit to harass someone or to get them quieted so they can't speak, he said something mean about me, or he said the truth and I don't like it, because sometimes the truth hurts about us, right? That you use a lawsuit because you got money to pay a lawyer, that just comes across as kind of a I don't know what word to put to that. My go-to would be a douche move. So I'm the more I learn about this New Zealand law, the more I think you guys are pretty enlightened. Honestly.
I mean, I mean, it does help that we only have a population of 5 million, so we don't have to deal with a lot of the issues that the US does, where what do you do if like 190 million people over here want to change a law, but the rest of the country doesn't? Well, it's only 5.5 million people. You can change laws and adapt things fairly easily. When, you know, obviously the US has its own challenges with much bigger systems and that. And also, one of the interesting quirks of New Zealand is we don't have a formal written constitution. We instead have a collection of practices and documents, which we refer to as our constitution.
Okay.
So we don't have the issue where you can come across in the US where the country just really wants to pass a law, but the Supreme Court says that no, this one clause in the Constitution from 150 years ago says no. So now you need to ratify a majority of states and go through like a multi-year process to adapt a law. And that obviously provides some security, but it's obviously very frustrating when people are trying to, you know, progress things or things like that. And it would be extremely frustrating, for example, if they did pass a law like this and then the Supreme Court went, conflicts with the First Amendment. No.
Kim, I really want to sit down with cups of coffee and discuss politics with you at some future date. I'm thinking like this would be a really fun discussion at some future date. We have to do that. Seems like a bunch of stuff in yeah, I don't even want to touch California. So
it's weird when it happens in California because like their bar exam is supposed to be one of the hardest in the US, so you would think they would have better lawyers, but
and again, I don't want to touch that. It's because honestly, as much as we like to in this part of the country, we like to badmouth California. There's a saying: as California goes, so goes the rest of the country. Because you know, California does stricter emission standards. The car companies have to look. They're not going to have two factories producing cars. They're going to have just one factory producing cars, and that car is going to meet the standards that will let it sell in all 50 states.
Yeah.
You know, so it's complicated. This has been a great discussion. You know, if I'm going to give 2 seconds, not 2 seconds, but I'm going to give about 2 minutes to anybody in the chat. If there's a question I have failed to ask, because I'm like, in my head, the wheels are turning on the things I haven't asked. And I'm like, dude, man, Kim, we gotta sit down with coffee and talk about some stuff. I'm really fascinated with the New Zealand Constitution now and this whole idea of freedom of speech versus freedom of expression. But you know, are there any questions that anybody can think of that I have not covered that I should have? And I'm looking over at the good wife who's been quiet this whole time.
No, you've done great. I don't think there are any questions.
All right.
And thank you to Kim.
Yeah.
Yes.
There was one in there that we didn't get time to address that I can just comment on because it was from DM Kurt. Is there a not guilty by reason of insanity defense in bankruptcy court? I thought I would just address this one because the insanity plea is probably the most completely misunderstood thing in law, in the not just the common law but the entire legal system. The insanity plea can only help you if there is a prerequisite mental state required. So there is, for example, murder requires that you have an intention to harm or kill the victim. So if you were insane and so you couldn't intend and control or have any intentions, you can argue that you didn't meet that one criteria point, basically. Like,
Okay.
If you tried to plead it in bankruptcy, you would, basically be confusing the judge because the origins of bankruptcy are essentially that you have, or another party has gone, this person doesn't know what the hell they're doing with their money. They can't be trusted to be responsible. They need to have control of their money or their assets taken off them and handled by a responsible and qualified adult. So if you were to argue I'm insane in bankruptcy court, the judge would just be like, well, that's a good reason to keep you bankrupt then.
I can think of people I would nominate to have their money controlled by a responsible adult.
Yeah, well, I mean, that's why there are people who get like conservatorships like Britney Spears had. That was the actual intention of that legislation that she was under for years and years, was like, look, you can't be trusted to be responsible and control yourself. You need to, and you have this staggering amount of money which is intended for your benefit. You need someone to make sure you don't like invest it all in imaginary cryptocurrency that isn't even a cryptocurrency and doesn't exist, and just wire it to a random stranger and things like that, or you know.
Yeah.
And there are legal things in there, but bankruptcy is one of those protections where basically the idea is, yeah, I'm not capable of handling my money. Look at how much debt I've gotten into.
So there's a number of thank yous for you in the chat. I don't know if you saw those from here we are, RPG Grandma and Wizard Tower Games. They both had very specific thank yous for you. I'm very appreciative of you coming on the show, and this was absolutely fascinating. And it is, I have a brain that has to stay active, and it has lit me up. And I'm really grateful to you coming on and explaining the ins and outs of common law and New Zealand law. And Kim, thank you so much for all that you do for the RPG community.
Yeah, you're welcome. And yeah, we can do more of these in the future if you like. And if you like what I'll do once we're done is I'll chuck in the comments some links to that actual law. All New Zealand law is made as accessible as possible. So if people want to have a look at it, want to confirm what I'm saying, form their own opinion, not just trust me on what I say, they can. That includes, looks like he's gone, but yeah, VG buddy, if you want to look at that and look at the clauses that involve jail time, I'm happy for you to do that because it's your right, and you have a right to freedom of expression.
And then bringing up VG, VG, please, if Justin has suffered some mental anguish, anxiety, harm of some sort, please encourage Justin to get some help, to go to counseling, maybe check himself into an institution. He honestly, he really does need the help. So I do want to get that in there because I really feel like if it's true, he needs to get the help. So I want to encourage VG, please do diligence and encourage Justin to do the right thing.
It sounds like Justin listens to VG. We know he doesn't listen to us or doesn't value our opinion. So there you go, VG. Maybe you can be the person that helps him out in that respect.
Be the go-between. Be the bigger man, VG, please. And again, so this is Tabletop Tap Room. I'm so grateful to you, Kim. And the sun is going in and out of clouds where you're at, and then you get dark on screen. So this is probably a good time to.
I look like I'm in witness protection.
You're in witness protection from TSR.
Yeah. I'm not even an insider. I know literally nothing about their goings on. But yeah, like I could turn for more better dramatic, and then I'm just look like I'm talking to something over there instead of to you. So
that's all right. I'm looking at the screen over here and then back. Yeah, it's all right. But again, Kim, thank you for coming on the show. Thank you to everybody who was in the chat. I appreciate it. And this was super enlightening. I'm so grateful to everybody who was here, even to VG. And we have some evidence about who you are. So I might actually send you a email tonight, buddy. Just a personal thank you. And again, thank you to everybody for watching. Thank you to my subscribers. You guys are great. And, keep on gaming. Kim, it was a pleasure.
Lovely being on. Hope we get to chat again soon.
Yeah, I wanted you to have the last word there. So,
no worries. Happy to be on. It was great to get to talk about this, and just share a few things and validate my ego with everybody saying thank you to me. So there you go. If you ever need me to come on and do this again, just let me know.
All right. Will do.